Welcome to Constant Variables, a podcast where we take a non-technical look at building and growing digital products. I'm Tim Bornholdt. Let's get nerdy.
Welcome to another episode in our Oofda series, sponsored by the Jed Mahonis Group, where we bring in an expert to give you a bite of what you need to know about a technical subject and then link to resources in our show notes where you can dive deeper. Remember to check out our glossary of tech terms at jmg.mn/glossary for any of the jargon dropped during this conversation with business attorney Susan Markey. And we feel obligated to mention that this casual episode is not legal advice. You can find Susan's contact info in our show notes for that.
Hey, Susan, welcome to the show.
Thank you so much for having me, Tim.
I don't think maybe there's a whole lot of people that say they get excited to talk about non-disclosure agreements and patents, but I legitimately am excited to have you on to talk about this stuff today. So maybe give the audience here a quick, brief background on what your law specialty is and how you got into this area.
Sure. So how I developed into my career was not such a direct path. It was a little bit winding, but I worked for the courts for a period of time. And whenever I would be in court, there would always be all of this evidence that was admitted from tax returns. And I thought that's interesting because I'd look at the tax returns and I didn't really, have a deep understanding of business tax. But the judges always found that to be the most credible and admissible evidence whenever we were arguing about anything related to finances. And I went, I really need to learn more about tax returns because everyone thinks that they're so wonderfully credible. And this was after I was in law school. So I moved from the courts to working at a public accounting firm. And I learned so much about taxes and tax returns that sort of became my subspecialty in my practice of law. And after I felt that I had sort of learned all of that, I transitioned from accounting firms into working for law firms as a corporate and business expert. So.
Right on. That it's nice to have that kind of winding path. It's odd to me these days to have somebody that just has a straight shot of they know what they want to do. They do it for 60 years. They retire and they're satisfied. It's there's so many ways when you get start going down the path and peeling the onion a little bit where you're ooh, okay, this is an interesting, turn of events. Let's pursue this little layer. And then you just keep digging down and moving, I guess in that metaphor, you're moving to different fruits.
Right. Well, I have the opportunity to work with a lot of law students who are at the beginning of their career as part of recruiting. And I always tell them, you're probably going to change your mind about what you'd like to do in the practice of law 3 or 4 times. And that's okay. And indeed, that will be part of your success because each time you're faced with an opportunity of, do I like this better? Do I like that better? You're going to move closer to the place where you're supposed to end up.
I love that. Well, the area we're going to focus on today is around intellectual property. Sometimes people call it IP. And when and where non-disclosure agreements and patents play a role in protecting that intellectual property. So I figured a good place to start, even in that sentence was probably a lot for some people. So I think where we can start is just kind of breaking down the terms intellectual property, NDA, patent. Could you explain what each of those mean in layman's terms?
Sure, absolutely. So, the thing that's really interesting that we've seen now is intellectual property is now generally the most valuable asset that a business has. And by intellectual property, we're generally referring to intangible property. So something that you can't touch that's created by the human mind. So it can be literary works and symbols, it could be names, it could be designs, it can be inventions. And the sort of traditional categories that lawyers usually think about are things like copyrights, patents, trademarks, and trade secrets. So intellectual property has sort of become increasingly broad over time as our economy has changed and become more digital and more innovative. These things have really become more important to businesses. And so in my role as sort of corporate counsel, I work a lot on the sale of businesses. And generally, when you transition a business, its most valuable asset is its intellectual property. Oh, you had also asked me about what's an NDA and what's a patent. So an NDA is an agreement. We usually refer to it also to sort of explain it a little bit more simply as a confidentiality agreement. And that means it's a contract between two parties that says there's information that the parties would like to share with each other for certain purposes, but they also want to restrict access or the ability of the other party to disclose that information.
All right, I think that makes perfect sense, and that's kind of where I wanted to start too with NDAs, because our company works with a lot of startups, and we
Sure.
hear a ton of ideas all the time, and the line at which you sign an NDA in my eyes is different than the point at which maybe a founder would want to have an NDA signed. So I'm really curious to hear what is your general advice around NDAs? Like what point would a non-disclosure make sense to bring into a conversation?
Well, the thing that's interesting about that is it depends on if you're representing the discloser, right? Who's usually a
Yeah.
seller, or the buyer. So the buyer, of course, or the other party of the transaction, always wants the most limited NDA, and they want to sign it at the latest possible point in time. The person that has the valuable information that is sharing wants the broadest NDA, and they want it signed at the earliest possible time. So a little bit that the answer to that depends on who I'm representing. But what I generally tell people is when you're at the point where you're going to share something that's valuable about your business and you want to make sure that the other party can't use it in a way that would disadvantage you, that's when you're ready to sign the NDA. So if you're sharing something that's on your website, that's generally available information about what kind of business you're in, your industry, sort of your real general initial talks, I would say that it's too soon to sign an NDA. But if you're sharing something where it's either party is sharing a little bit of their secret sauce, it's time to execute that NDA agreement. So you just want to think about, could the other person replicate what I'm doing, steal valuable information, approach customers, approach my employees, that sort of thing. If there's a risk of that based on the discussion that you're having, then an NDA is appropriate. If there isn't a risk, that kind of risk based on the discussion that you're having, it's probably too early for the NDA.
Okay, so I think that I love that summary. I'm thinking about it. I try to think about things from both sides of the table. From my side of the table, I know how to build technology. Like if somebody came up to me with an idea, as long as it wasn't something like, fantastical of extract all the carbon out of the atmosphere, like I would have no idea how to do that. But like if it's, hey, I want to make the Uber for dog walking, I know exactly how to build that, and I could do it in a reasonably short period of time. But, from my standpoint, I would not be getting paid to do that, which is what I'm aiming for. And B, it's not an idea that I'm jazzed by necessarily. Like I could do it, but I'm not going to. Where on the other side of the table, you've got somebody that is really enthused about building the Uber of dog walking, and they think
Right.
that just by walking into a tech company and telling them, hey, I want to build this idea, that they're just going to take that idea and steal it. So my question, I guess, around this is, what when you're advising on the startup side of things, of somebody that has the idea that they want to protect, how do you find that balance between protecting a general idea of a thing that could exist in the world versus like, here's the nitty gritty step 1, 2, 3 of how I'm going to execute on this idea?
Well, I think that what you're really talking about is a difference between a concept and protectable intellectual property, right?
Yeah.
Lots of people have lots of ideas. Those are concepts, but they're not really inventions, processes, or products that would really be patentable. So in sharing them, you're not really giving away the idea. So saying we'd like to have the Uber of dog walking, that's not really where the value lies. The value lies in how do you execute the Uber of dog walking, right? That's where that information comes into being. That where I say you could reverse engineer, you could compete. That's where I get really concerned. At the general conceptual level, when you're just selling your idea, you can't really sell your idea without sharing it generally with a broad group of people. The other problem with that is, so startups always want to get everyone to sign an NDA right away because they think their idea is so unique and no one will have ever heard of it. But when you're dealing with the kind of counterparties that are interested in technology startups, they're the big ones, they're not interested in signing an NDA right away because they want to keep their options open to talk to all kinds of people about all kinds of ideas. So if you told me, for example, you had a great idea and you wanted to approach Amazon, well, Amazon isn't going to want to sign an NDA just based on the fact that you're going to share your general concept with them. You would have to be sharing something that would give them some sort of competitive advantage before they'd even be willing to engage in that sort of NDA process. So it also depends a little bit on who the counterparty to the NDA is. If you're just working with, say, an independent contractor that you might hire to help you produce part of this idea, they would probably be willing to sign the NDA straight away, up front. So it kind of depends also a little bit on who is going to be on the other side of whatever the particular transaction is.
Yeah, there's definitely power on either side of the table, and you kind of have to figure out and feel out where it makes sense. It's a delicate dance, but it's interesting if, I can feel out a first time founder pretty quickly when it's like they reach out to me and they say, I have this idea that will change the world, but you need to sign an NDA before I tell you the idea. From my standpoint, I'm like, all right, well, that's not going to happen. Where if I have like somebody that comes to me with, 20 years of entrepreneurial experience and they say, this is my idea and I'd love to sign something to talk about it in more specifics, then I might be more interested in it. So it really is kind of you feel it out on a case by case basis.
Right. And it is, if you're going to ask everyone to sign an NDA before you can even explain your concept in general terms, you're going to have a lot of trouble getting financing, getting assistance, getting investment, getting the things that you need to really grow and scale a business. So you have to, and I tell this to entrepreneurs all the time, you have to have a general way to explain your concept that doesn't reveal what your secret sauce is, right?
Yeah.
So usually there's it's the 10,000 foot level of this is my idea, and you have to be comfortable with the fact that you're going to have to share that. And there's a level of trust involved in that. And that means that when you're approaching partners, you should make sure that you're approaching people that are reputable, that, you didn't just Google and say, I think that I'll call this first person that was listed as person that invests in small businesses.
Right. And I think you hit on a key word that I think about with NDA, and that word is trust, because that's,
right.
Effectively you're trying to, with an NDA, I think a lot of people try to wield it as a tool to enforce trust being thrust into the relationship, where I think of, I don't know if you've ever watched The Office, but there's this scene where
yes.
They talk about like, I've never seen a successful marriage start with an ultimatum.
Right, it's true.
And I think about that with NDAs. Like, if you're going to come to me and like immediately question my ethics and my ability to, help you out with your idea, and you won't even trust me enough to tell me generally what the idea is, that I feel like we're starting off on the wrong foot. So my question is, I think a lot of times people use NDAs as that they force a way to establish my idea is never going to get stolen. But I mean, can you just settle this once and for all? Like, is me signing an NDA going to mean that I've been fully protected and there's no way that my idea will ever get stolen?
I mean, unfortunately, no. Agreements are only as good as the terms within the agreement. And you have to, generally, when you sign an NDA, you're going to identify what information is confidential and how that information can be used and what a permissible use is. But ultimately, an agreement is only as good as the court that's interpreting and enforcing it. So I can write you the best NDA in the world that says that no one can do anything in the industry in which you work ever again. But if a court reads it and says it's unreasonably restrictive, that doesn't really help you particularly much. So don't get me wrong, NDAs are very important, and I advise that people sign them and have them to protect their intellectual property, because it demonstrates to your investors that you're being savvy about protecting your business's most important asset. But it's also not a sort of impenetrable suit of armor or something like that.
Oh, good. I'm glad you said that, because I feel like that's how a lot of, especially first-time startup founders and entrepreneurs kind of approach it, is everyone's worried about people stealing their ideas, when at the end of the day, an idea is just an idea. Like ideas are dimes a dozen. And in many cases, it's all about those other, like you identified with, like, there's processes, there's like just trade secrets, there's actual ways of going about executing on the idea. That's where the value is. And when you start to get into that territory, I mean, from my standpoint, at least, that's when I start to say, like, okay, now we should probably be signing an NDA.
I agree with you. To me, your general concept, I understand that from a founder's perspective, that's their baby and they're very excited about it. But to me, that's less valuable than your techniques, know-how, processes, and everything that goes into executing that concept. And I think that that's really what the NDA should be aimed at protecting, is those techniques, know-how, processes. And generally, you broadly include all of those things under the umbrella of confidential information. But that really brings us to what I would say is one of the biggest issues in an NDA, for example, is what is covered by the definition of confidential information. Because if the wording is ambiguous in any way, if the contract language in your NDA is deemed to be ambiguous or conflicting, courts look to the intent of the parties. So that can get you into, once again, sort of the wild, wild west. So, there's been cases where people's NDAs have said that confidential information would be information that's confidential and proprietary, including without limitation information about operations, technology, or systems. Well, a court in the Eastern District of New York interpreted that term as saying that it only meant operations, technology, or systems that were confidential or proprietary in the first instance before they could be protected. The person that had asked the NDA to be executed thought that that meant that it protected all of their operations, technology, or systems. So the wording and the definitions in your NDA are extremely important. And I always say the definition of confidential information is the number one most important term in your NDA. And in particular, generally, most NDAs are drafted so that your confidential information broadly includes one category of things and then also has exclusions, things that are not treated as confidential information. And those are equally as important as the things that are included in the definition of confidential information.
So you're saying it's probably not a good idea just to Google NDA for startup and just use that as your NDA.
Well, when you talk to a lawyer, they're always going to tell you that you need a lawyer, right? So you've called the wrong number if you were looking for an endorsement for LegalZoom. But yes, for someone to draft a good NDA for you, they need to understand your industry and your particular business. So if I were to draft an NDA for you today, I'd start out by saying, what is your secret sauce? What gives you your competitive edge? What makes your business valuable that your competitors do not have? And what are the things that if someone else had access to would greatly diminish the value of your business? And that discussion is what starts you on coming up with an appropriate definition of confidential information. So a super broad boilerplate definition of confidential information is good from a seller's perspective, but you also want to make sure that it's tailored to cover the specific types of information that are key to the particular business that you're working with. So if I were to use a broad definition that said any confidential information, and for some reason your business is focused in the arena of, I don't know, taking photographs, I would really want to be very clear to enumerate that I was including photographs if that was a key component of your business. Or if your business was really focused in the arena of, techniques for using a certain type of software, I would want to say techniques and including but not limited techniques related to that kind of software. So those kinds of specific call outs can be very helpful in addition to that general language, because you have to think about the fact that a court that might be interpreting an NDA in the future they may be a trial attorney, someone whose background is litigation, who doesn't have business law experience, and that might be the first NDA that they're looking at. So you want it to be very clear what is intended to be covered by confidential information.
Excellent. I want to switch topics a little bit but still stay in the IP space and start talking about patents, because patents to me are another area where I have a lot of opinions on them, but I don't know if they're like well-founded. So talking to an attorney and getting that perspective I feel like every time I talk to attorneys about patents, I feel like my worldview gets shifted a little bit. So I in a similar kind of question, maybe again, like a little bit of a tongue in cheek, but I feel like people wield patents much like they wield NDAs, in that the fact that you have a, say, provisional patent or just, any kind of patent means that you are immune from any sort of, problems going forward in the future. So I'm curious from your perspective, like, what, maybe start with like, what is a patent? Like, what does that cover? And then what, just kind of going down the road a little bit, what doesn't it cover? What aren't you protecting yourself from when you get a patent?
Right. Well, so a patent is essentially an exclusive right granted by the U.S. Patent and Trademark Office for an invention, a product, or a process that purportedly provides a new way of doing something. So the interesting thing about a patent that I really think that most people don't realize is, A, patents have limited terms. So a patent is not forever. And B, to get a patent, you have to disclose technical information about the invention to the public. So one of the ironies of a patent is that sometimes we advise people that if they really have a very specific process or technique for doing something that would not otherwise be public, that applying for a patent may not be the best option for them. And the other thing that's interesting, that sort of is a limitation on patents, is you can only patent eligible subject matters. So it has to be, the subject matter has to be useful, novel, and non-obvious. So it can be a process, it could be a machine, it could be manufacturing or composition of a matter, but not everything that we think of as being secret or proprietary is necessarily patentable. And to the extent that you get a patent, it's beneficial in that you can say that it's patented, but once again, a protection is only valuable to the extent that it's enforceable. So there are a lot of infringement issues every year, but actually there's only around, I believe the number is less than 3,000 infringement suits filed every year in the United States, which tells you there's certainly more than 3,000 cases of infringement that are taking place in the United States every year. But infringing a patent enforcement action is expensive and it's time consuming. So once again, just like I said about an NDA is only good to the extent that it's enforceable and that you have the means to proceed to court to enforce it, and then the court is willing to enforce it. And the answer is similar with a patent. You have to have the means to enforce it, and the USPTO has to determine that it's enforceable with the federal court. So it can be a extremely expensive and long process. So to say that a patent makes you bulletproof is not exactly accurate.
That's what I've always heard too, is like patents, unless you have a deep war chest, like the example I always give is if you come up with a product and let's use Facebook, because I've beat up on Facebook almost every single podcast that I do here. So why not just continue to pile on? And frankly, I could see them doing this, but Facebook, let's say like you have an idea that is really great and you patent it and Facebook sees it and they try to buy you and you say, no, you're not going to buy me. They could turn around and just do the thing that you patented. And what you could do is you could go to court and file a patent suit and say that they're infringing upon you. And Facebook could turn around and use their 9-figure-a-year legal budget to stifle you with like continuances and all sorts of just legal runarounds, to the point that they just bleed you completely dry and you're out of luck. Now, could they do that and would they get away with it? There's all, it's all a bunch of what ifs and what could happen, but that's just kind of like what I think of in the high tech space, especially, is it's really hard to actually have a patent and say, like, I'm protected, no one's going to take my thing, and if they do, you're going to get in trouble. It's like, well, in a perfect world, yes, but in this world, you got to have the war chest if you're going to actually, try to go after somebody that takes your legitimate patent.
Right, absolutely. It's a very expensive process. And like you said, a patent isn't an absolute prohibition on someone else doing it. It just gives you the ability to pursue a suit for infringement, right?
Right.
So, of course, we always hope that a patent would serve as a deterrent and that they would weigh that in the risk in evaluating whether or not they should take that action. But in law, there is always the concept of, an efficient breach, meaning they can take a look at the risks associated with doing that and the costs and weigh it against the potential benefits and decide, yes, maybe technically we don't have the right to do it, but practically we could try it and see what happens.
Yeah. One thing that I've been thinking about a lot lately is just how technology patents in general have kind of evolved over the last few years. And, it seems like to me, and again, I'm really glad I'm talking to an attorney on this so I can get fact checked and put me in my place if I'm wrong. But I personally have a belief of, like, patenting math seems like something that we shouldn't do. But there have been so many patents that have been granted over the last, decade, 2 decades, 3 decades that, give people an advantage about something that is not, necessarily what I would see as patentable. But what I'm curious to hear from your perspective as an attorney, A, am I kind of on the right path with that line of thought? And B, how has technology patents been changing over the past years, and how have the laws around protecting technical ideas changed, and where do you see it going here in the future?
Well, I mean, a lot of things have changed. The problem that we always have with laws and technology is the laws are chasing the technology, and the technology tends to develop first, and then the laws develop in response to the technology, and the legal process isn't fast. So by the time we catch up, the technology is in sort of a whole different realm. So, for example, one issue that people have really been talking about recently is whether computers could patent AI inventions. So generally, the patent office has a requirement that a patent application has to identify an inventor. And an inventor is currently defined as an individual. Well, a machine is obviously not an individual, right? So how could a computer patent an AI invention? And the US Patent and Trademark Office has rejected attempts to name an AI system as an inventor in patent applications and said that the inventor is limited to a natural person. Practically speaking, though, from a technological perspective, I think that we're going to see a lot more AI inventing things. And I think that that will be an arena where we'll see a lot of disagreement about whether or not AI can be an inventor. And I know that people have differing opinions about that, but I think that that's an area that's really interesting to me that I think is evolving and will continue to grow. I'd say another change that we've really seen in the past decade is there was a pretty famous case called Alice Corporation v. CLS Bank International, where the Supreme Court ruled that applying an abstract idea on a computer is not patent eligible. So if a computer software program took an abstract idea and implemented that idea electronically, it couldn't be protected by patent law. And in that case, I believe they were talking about hedging currencies. But that led to a lot of software patents being invalidated because they were deemed to sort of be in that arena, that it was just taking an abstract idea and doing it electronically. And that led to the patent office really has issued very few software patents since that case came out. And that's a big change. I think that people envisioned that a lot of software would be patentable, and now we're sort of getting to this new space where software is deemed to be less patentable. We have this AI space that's really changing a lot. Another thing that I really think is movement that I've seen in the past decade is it used to be that IP was very jurisdictional. So, for example, if you get a patent in the U.S., that's protecting usage in the U.S., right? But unfortunately, our economy is increasingly, as we've all seen with remote work, with how we've responded to the COVID pandemic, it's increasingly global. So my sort of prediction that the movements that I see next are going to be, there's going to have to be some movement around the international protection of intellectual property, because otherwise these rights are becoming substantially meaningless in a lot of ways.
Oh yeah, like, and I know like China's also kind of a hot topic that kind of gets dragged through the mud quite a bit, but it's for good reason in that, when you do file a patent, like you said, you're putting everything out there that the public can see, including people in countries where that patent doesn't mean anything to anybody. So it's hard when you just kind of give up your secrets, and any company that, or any country that chooses not to follow whatever laws you may have regarding protections, it's all like the globalization of technology has changed things so rapidly. And I'm glad you touched on, I didn't know about, that's why I love this podcast, is I get to learn new things about this space. And I didn't know about those changes to the laws and that Supreme Court decision that has made software patents less enforceable. Cause it's always been so confusing to me as to how you could patent something as simple as, like, we've had certain clients over the years that have tried to get their software patented and have succeeded. And I've kind of looked at it and been like, like you identified before, there's like a novelness to it. There's like a non-obvious thing. And it's like, maybe math and things like that are non-obvious to non-technical people, but to me, as someone in technology, it's very obvious to me. And that's like why I think when you're talking about the laws being slow to catch up too, it's because you also have a lot of people that are making the laws where, you put Mark Zuckerberg on the stand and say, how does Facebook even make money? And it's like, why are you sitting there asking him that question? Like, there's a million other questions you could be asking this guy right now, and that's the question you're asking. Like, it's all just such a dog and pony show in the first place. But it all goes back to like tech literacy, which is why I'm glad you're on the show today.
Well, and it's true that lawmakers tend to be of an older demographic that are less technologically experienced, so they don't really understand a lot of times the concepts that they're dealing with. So, like I mentioned at the beginning of the podcast, one of my focuses is on technology and taxation. So I've done a lot of work related to sales tax and software as a service, which I'm sure is another issue that you've probably covered at some point in your podcast. And trying to explain to a 60-year-old revenue agent from some state, in Kentucky, about how this software is hosted and what the purpose is and how it's being used, it's sort of like you're telling them a fairy tale or something, right? They keep asking you, well, is it downloaded and did you send a disk? And you're like, no, that is not what we're talking about. So it is true that there are generational differences that impact how our laws are developed. And I think that that's why you'll see a lot of change, is because people that are technology natives, right, are going to start to graduate into more of that legislative age band. And I think that that will really hopefully help the law advance, because there will be people like yourself that have that really deep technological background that will come into those legislative positions. And I hope that that will help getting laws that are common sense and practical, and not just relying on the technological practices 20 or 30 years ago. So, I interact with the IRS for a lot. So that's an example. They only will accept faxes. You can't email anyone that works for the Internal Revenue Service. Well, how long has email been a widely used business practice in government and in private industry? Forever, right? And when you say that, they say, well, we're the IRS. We don't do that. And so I just think that that's like a little micro example of how our government, and particularly the federal government, really lags behind in that technology space. So it'll be interesting. The other thing that I did want to mention, though, when you had asked about historical changes that have changed IP treatment in the United States, is I forgot to mention the America Invents Act. So in the United States, historically, the inventor that first invented an invention received priority in patenting their invention. But the America Invents Act was passed in 2013, and that changed this rule to provide that the applicant who files their patent application first receives priority. And the reason that I think that that is really an important rule change is because it does really benefit people that have deep pockets and can go and file patents right away when they come up with an invention. And I think that the previous, our historical policy of first to invent, receive priority in patenting their invention, that policy really was something that benefited smaller inventors, because if they could prove they invented it 10 years ago in their garage, they would get priority even if Apple tried to tried to patent it, on the 11th year. So that's another big change that I think has really moved a lot of the way that we see people using their patent application techniques. We used to be able to tell people, well, if you can establish when you have invented it, that can give you priority in receiving a patent. And now that's just no longer the case. So if you have a good idea and you want to patent it, you're not concerned about providing the technical information to the public, I would encourage you to seek patent advice right away.
Oh, that's great advice. I should have you on for a round two, because I have like 6,000 follow-up questions on that. But I think what the last question I really wanted to make sure we left time for was, I think a lot of times the advice that you give your best friends is different than the advice that you kind of just give the general public. So again, now that we've been best friends for a half hour here, if I came up to you today and said, I'm thinking of, doing a startup, and I have some innovative ideas for software, and I want to go about protecting them the best way, and I want to learn more about like what I need to do in order to get this, where would you direct me? What resources would you say, check out this, go look into this? Where would you send me?
Well, the first place that I would tell you to look is uspto.gov. And they have a good section on fundamentals for entrepreneurs that explains some of the general terms, things that are and are not protectable. And I think that that's a very good resource to look at. That said, I find that some entrepreneurs find their information to be a little on the technical side. So another place that I've seen that has a really great resource is the University of Michigan College of Engineering Center for Entrepreneurship has a great video series on intellectual property basics. So they have, what is a patent? When is a good time to patent? What is patentable? What should I concern? And they're all videos done by different professors from that school that sort of give you the basic sort of fireside chat about what do you need to know. And I think that it's very smart if you take the time to review that information before you go out and have a conversation with an attorney, because it will save you money, because you'll be able to identify, okay, here's the information that the attorney needs, here's what's key, here's what isn't key. And I hate to say it, but when someone is billing you by the hour, if you come in and spend a lot of time telling me about your feelings about what you've invented or just extraneous information, I still have to bill you for that, right? And you don't want to get that bill with all those zeros at the end. So I think that it's a really important step to sort of educate yourself on the basics. And that way that attorney doesn't have to spend that time telling you these are the basics. Now, that said, of course, your attorney would be the best person to analyze anyone's individual situation and give them advice. So these are just general resources. They're not a replacement for legal advice. They don't serve as legal advice, but I think that they help you become a more educated consumer of legal advice. The other thing I would say is the USPTO, of course, is aimed at the United States. I also like the World Intellectual Property Organization, which is WIP. You can access their information at wipo.int. And they have more of a global perspective on intellectual property. So if you're interested in learning about the global aspects of intellectual property, that's also a good resource to check out. So those are kind of my three basics that I tell everyone. If you know nothing, but you know that you have some good ideas and something that you're interested in protecting, those are a good place to start out.
Yeah, those I'd say, first of all, if you're going to be paying someone by the hour to talk about your feelings, therapist might be a better place to start. But I mean, I don't know, it could be equally as expensive these days. So you just got to kind of see who you're footing the bill with.
Well, you would be surprised, because people, when they develop intellectual property, and entrepreneurs in general, they're so proud of what they've built and created, as they should be. It's their baby, and it's something that's very special to them. And when they feel that it's at risk or that someone else is threatening it, there are a lot of emotional aspects involved.
Yeah.
But I just always tell people, like, call your best friend, say this person is a jerk, talk to your partner, but don't pay a lawyer to listen to you say how much you hate this person for what they're doing. Instead, just tell me what they're doing so that we can develop a plan.
Yeah, just the facts, ma'am. I think
Right.
the other thing I'll add too is I'm one of those nerds that likes looking at public records sometimes. Like that might be my journalism degree that came into it. But I think like using the USPTO's website to do patent and trademark searches and just kind of play around with it and see what is out there is actually kind of fun. If you have an idea and you actually think it's novel and unique, take a look, see if it actually is, do a little bit of research and do it on your own dime. It's all public information. And, if you have questions, obviously go talk to a lawyer. I mean, we'll throw in a disclaimer before the episode here. And I'm glad you threw it in there as well, that, this isn't specifically legal advice for anyone in particular. It's just more of our own informational, what's worked for us in the past. And I think, when I've looked at those websites and played around with it, I've been beat down more than enough times to say like, oh, my idea isn't a precious snowflake. Someone else has thought of this many times for many industries. So.
Yeah, no, I agree with you. It's actually shocking how many times someone will approach you and say, I have this wonderful idea. I want to see if it's patentable. And you'll do a search and you'll say, no, it's not novel. Someone else has already come up with it. But, that's sort of, I guess, the curse of human intelligence, right? Everything seems to be recycled in some way or derivative in another, right?
Oh, yeah. Everything is a remix, as they say.
Right. As the kids say.
Susan, this was amazing. I really appreciate you coming out and talking with me here today. Where can people learn more about the work you do and the work that Maslon does?
Sure. So Maslon.com is our firm website. That's a great spot to learn about us. And we have a varied intellectual property practice. So we have people that focus on intellectual property and technology transactions, contracts. We have people that focus on litigation in this area. So we have a broad array of professionals that work in this arena. It is certainly not just a one-woman team. And also people, if they would like to reach out to me or connect with me, I'm on LinkedIn. I always love meeting new people and hearing about what they're doing in their businesses. So thank you so much for the opportunity to chat with you today.
I really appreciate you coming on, and we will thanks for coming on, and we'll be in touch soon, I'm sure.
Thank you so much.
Thanks to Susan Markey for joining Tim on the podcast today. You can learn more about Maslon Law at maslon.com. Show notes for this episode can be found at constantvariables.co. You can get in touch with the show by emailing hello@constantvariables.co, or you can connect with us on Twitter at CV_podcast. Today's episode was produced by Jenny Karkowski and edited by the caring Jordan Doust. If you can take 2 minutes to leave us a rating and review on Apple Podcasts, we would greatly appreciate it. And to show our appreciation, we will give you a mention in a future episode as a thank you. Visit constantvariables.co/review and we'll take you right there. This episode was brought to you by the Jed Mahonis Group. Check us out at jmg.mn.